Car crashes are a leading cause of injury and death in our society. Everyone needs to know what their obligations and rights are when involved in a car crash. Welcome to Lawyers on the Line. I'm Sean Quinn, a partner at Falsani, Balmer, Peterson Quinn, and your host this evening. I'm pleased to welcome our guests, Rob Barnes, a partner with the McCarthy Barnes law firm, Bob Falsani, a partner with Falsani, Balmer, Peterson Quinn, and Jim Balmer, also a partner with Falsani, Balmer, Peterson Quinn. We're ready for your questions. Call the numbers at the bottom of your screen, 218-788-2844, or toll free at 1-877-307-8762. And now, tonight's topic. So, gentlemen, we advertised this show ahead of time. We already got some calls in. Rob, start with you.
All right.
We got a caller from the Schultz Lake area.
Okay.
My wife likes to multitask while driving. While putting on lip gloss, she went off the road. I'm her passenger, and I got hurt. Can I sue my wife?
You absolutely can.
Should you?
That's a question beyond my grade. And what you're describing, whether it's lip gloss, texting, talking on the phone, reading the newspaper, we've all seen it, but you're just hitting on distracted driving, which is clearly a big problem. But the short answer is yes, you can sue your wife. Whether you do is up to you.
Matter of familial peace.
I think one of the interesting things is that a lot of insurance policies exclude family claims. You know, like your homeowner's policy. Mm-hmm. You know, if your wife hits you over the head accidentally with a frying pan, you know, there's no coverage for it. But by statute, the auto policies cover that. So when you're suing your wife, you're really suing your own insurance company because there's insurance coverage. So in that respect, it usually doesn't cause a lot of family strife, except for in rare circumstances. But an interesting other point is how juries react to that, and maybe Jim wants to tell us about that.
Well, usually juries don't know that in Minnesota, juries are not informed that a liability insurer is behind the defendant, managing the claim, managing the defense, and paying any judgment. And as a result, some juries assume that the plaintiff is suing the spouse, and the spouse will have to figure out some way to respond in damages. In Wisconsin, which is very close to many parts of Minnesota, like the part we're in right now, the exact opposite is true, and the juries are informed that an insurance company is standing with the defendant. And I'm not aware of any significant difference in the verdicts when a verdict is returned. One of the rest of you might have noticed a difference, but I have not.
Give me Wisconsin any day.
Yeah, well.
Okay.
Rob, you were quiet on that.
I'm licensed in both Minnesota and Wisconsin. I've defended a lot of cases in Wisconsin where it's my client and their insurance company, whatever it is. I really haven't noticed much difference between verdicts where the jury is aware that there's insurance versus not aware. My guess is that most juries in Minnesota assume that there's some insurance, in part because during the jury selection process, they're typically asked about the involved insurer.
Sure.
Are any of you policyholders, agents, employees?
Of
And
XYZ
usually
insurance
that's
company,
a
yeah.
decent tip-off.
But the other thing is, how many times the jury's out and they're allowed to send the judge in a question? And what question do they ask the judge?
Who's going to pay in the insurance company?
Yeah, is there insurance coverage?
Right, yeah.
And of course, the judge can't tell them.
Right. All right, Jim, we'll go to you. Another caller. I was going 10 miles over the speed limit, but the other vehicle pulled out right in front of me. Who wins that lawsuit? Now, that's the question.
Well, I could tell you several things. The question in most automobile collision claims is whether the driver or drivers were negligent. And one facet of that is violation of traffic statute. There are some circumstances, very rare in automobile cases, where you are presumed to have been negligent if you violate a statute. Now, in the hypothetical situation you pose, the person who was driving 10 miles over the speed limit would have thought he had the right of way when the other driver pulled out in front of him. But if he was driving too fast for conditions, Minnesota statutes hold he forfeits his right of way. Now, that doesn't mean he then loses necessarily, but it does cause him to give up a legal advantage in the trial. If the other driver forfeited the right of way, then there are circumstances under which the judge would instruct the jury that the driver who pulled out was negligent and must be found partially at fault. And then the only question is whether the driver who was involved in the other driver, there, I got it out, was also negligent. But if the driver the other involved driver was speeding, he doesn't have right of way, and so it's a comparative fault situation.
Doesn't mean the guy with the stop sign can just, oh, I see him coming, but it looks like he's going fast, I'll just pull in front.
Right, because the guy who pulls out could still be found more negligent than the guy driving 10 miles over. But it's not as automatic as it is otherwise.
Rob, comment?
Two quick points. Number one, the jury's going to hear all about the speed. The jury's going to hear all about the other person pulling in front, and like Jim said, they are going to weigh it. Jim and I tried this case about 2 years ago.
Maybe it was one of your respective clients who called in with that question.
Who knows?
Well, they know the answer, at least in that case. But in that case, my client was going straight. Jim's client was coming along and making a left, and the police report said that Jim's client did not see my client coming, kind of pulled across. As we went through discovery, Jim very brilliantly had my client's data recorder from the car, the black box, analyzed, which showed she was going about 10 miles over the speed limit.
There you go.
The jury weighed all of that and rendered their decision. In that particular case, it fell in my favor, but those things can go either way.
And Bob, kind of a similar question. Another caller, I got rear-ended. Does that mean that the other driver, the driver who rear-ended me, is 100% at fault? Is that an automatic deal?
Usually is, unless you're really unlucky, you know. I've had cases where somebody stops for traffic and gets rear-ended, and the jury somehow doesn't like the plaintiff very much, the injured party, and they find a way to say that somehow they quick stopped so much that they're partly at fault or more at fault.
Okay, Jim?
In Wisconsin, there are jury instructions that are given to the jury, though, that instruct the jury that they can excuse the rear-ending driver if the jury finds that the truck or the vehicle that was rear-ended stopped unexpectedly. And you don't have that jury instruction in Minnesota. Now, the general rules of negligence are the same, but it seems to me that it's easier for the driver who does the rear-ending to avoid liability in Wisconsin than it would be in Minnesota. It's still an uphill battle, but it's not as steep a hill to climb in Wisconsin as it is in Minnesota.
Well, and it's funny you mentioned Wisconsin and Minnesota, because another caller, I was in a car accident on the High Bridge.
Ah, yes.
Which laws apply, Minnesota or Wisconsin? Rob, you get first crack.
We get more of those than you think. Accidents on the High Bridge,
Yeah.
Bong Bridge.
Long Bridge, yeah.
There is a dividing line on the bridges as to where Minnesota ends and Wisconsin begins. Sometimes there's a little bit of controversy about exactly which state it occurs in. There's usually one big clue. I mean, with an accident on those bridges, you often get emergency response from both sides, but the official crash report from either the Minnesota State Patrol or the Wisconsin State Patrol usually tells you, if you're looking at a Minnesota report, it was on the Minnesota side, but we get that more than you'd think, and I've had a couple cases where it was really close. Usually we let law enforcement sort that out, and the lawyers aren't battling it out.
The other clue is the mile marker. The report, regardless of which jurisdiction completes it, will give you a fairly precise indication of where on the bridge it occurred. And you can tell with Google whether it was on the Minnesota side or the Wisconsin side. And if the other side looks at the same Google map you do, there usually won't be a big battle over it.
The audience tonight didn't know we're going to have a boundary dispute.
Yeah.
No, there's real
confused.
estate and car crashes at the
right,
same time.
yeah.
All right, another caller. A person has a valid driver's license, but they're in the passenger seat, and their grandson, who's 16, but who doesn't even have a permit, is driving the car. What happens when the grandson is in an accident, whether it be his fault or not his fault? Bob, you can go
Well,
have
you're
that
going to be
one.
liable, in all likelihood, as the owner of the vehicle is liable under state law anyway, automatically for allowing someone to drive with their permission, okay? So you start with that. Then they're also liable because they're negligent and stupid. and then yeah. And then the
Remember
kid,
a caller.
the kid is likely to be covered by the insurance policy too, of course.
Okay. What if the kid is at fault and the other person in another vehicle is hurt? Jim?
Well,
The same kind of things Bob
Oh, you
is
mean
saying.
Wait, think
you're going to
Bob said.
sue the 16-year-old?
Well,
Yeah.
You mean so if the father or grandfather is hurt that he sues his grandson, he can do that because, as Rob pointed out, there's no family exclusion in most auto policies.
Yeah.
Although comparative fault is, why would you let an unlicensed 16-year-old driver operate your own car and then when you get hurt you sue him? The other hypothetical situation is somebody in the other car gets hurt. As Bob pointed out, they will sue the grandfather as the owner of the vehicle. In Minnesota, we have what's called the Safety Responsibility Statute, which holds the owners of motor vehicles legally responsible for the actions of the drivers. Now, there is not a similar statute in Wisconsin, but there is a similar law, and that's that the sponsor of a driver of a car in Wisconsin is liable for the actions of the driver. The sponsor is the person who signs off on the driver's license application. So
let's twist it a little bit. The grandson who doesn't have a license steals grandpa's car. Rob, now what?
Shelby Mutual.
The owner of a vehicle is liable, is at fault for the actions of a permissive driver.
So that was the statute Jim was referencing.
So if somebody steals my car and gets in an accident, my insurance is not covering that. You can't sue me because this is not a permissive driver. By the same token, anybody steals or anybody I give permission to, I'm going to be liable. And if I give my child permission to drive my vehicle or my neighbor, and then unbeknownst to me, my neighbor gives someone else permission, once I give initial permission, it's following that car around. So be very careful about who you let drive your car.
Yeah.
There is the exception. It's the beer truck case, okay? You park your beer truck in a real bad section in St. Paul, and it gets stolen, and then they run over somebody, then the beer truck company's liable. So if you're, and I've had this case, of course, like almost every case, but anyway, I had a case, and it's 12 o'clock at night. They leave the keys. It's outside of the bar. Everybody's drunk in there. Somebody wanders out, jumps in the car, steals it, crashes into somebody, and then we held them liable, so we actually won the case.
There's the circumstances of acquiring use of the car are important. The Shelby Mutual case I referenced was a case in which a father knew his son kept wanting to drive the car. He, the father, kept telling him, no, you can't drive the car, and then he left his keys out on the kitchen table while he went and took a nap. Kid took the keys, drove the car, crashed it, and of course, there was a lawsuit over whether the father gave permission, and in that case, at least, the Minnesota Supreme Court said, yes, that was implied permission, and like all these other cases, Rob and I have had that one at least once.
Right.
Well, yeah, if you
leave your keys laying around and one of your kids takes the car,
you can.
it's almost implied permission.
Well, you can be negligent in leaving keys around or leaving keys in a stopped vehicle. You see this all
like
the time.
the stopped beer truck.
Every Quick Trip and Holiday in Duluth, people are leaving their vehicles running.
Yeah, in the
Even
wintertime.
if someone steals it under those circumstances, the owner can be liable for negligently leaving the vehicle like that. But if you're at home, somebody breaks into your car, it's a little bit
Totally
different
different.
situation.
Yeah.
Okay, we'll change a little bit here. Rob, a caller, says, I treat with a chiropractor for my injuries from a car crash. Will the jury accept chiropractic testimony versus an MD testimony?
Chiropractic testimony is admissible. The jury is going to hear the chiropractor's testimony, is going to learn about the treatment, is going to hear the chiropractor's opinions, and then they're going to weigh those against, sometimes it's another chiropractor, more often it's an MD. There's a lot of personal injury cases where a jury is weighing an expert opinion as between a medical doctor and a chiropractor, and they weigh it. So whether they accept it or not, it really is a case by case, but they're certainly going to hear it.
I think things have changed tremendously in the last 30 years. Chiropractic treatment is a lot more accepted. Some doctors refer to chiropractors. And so I think you see a lot more willingness in the jury to accept chiropractic testimony, especially if the testimony is convincing and well done. If it's somebody that knows their stuff. And of course, they tend to know the cases really well because they see the person, 40 times or 20 times. Where you go into the doctor's office and they say, "Hey, are you still there? Great, nothing's broken. Bye bye." So a lot of times they know the case intimately.
I mildly disagree with
Well, I noticed Jim started laughing when Bob made that comment.
As a general proposition, I think if you have a chiropractor up against a medical doctor, regardless of whose side they're testifying for, I still think there's some disadvantage. There's difference in education and so forth, but there's also a lot of chiropractors that make better witnesses than some MDs. So it varies.
One last thing about that, then you can move on. It depends on what you're asking the chiropractor.
Sure.
If you're asking him whether the guy would benefit from spine surgery, that's different than asking him, you saw the man 43 times. Are you convinced he was in pain each of those times? Yes. Now that's different. So it depends on what you ask him.
Very good point. And Rob, that you commented on it, Bob commented on it, Jim laughed about it. Who are these hired gun doctors, a caller wants to know?
All the people he hires.
No, he doesn't.
You're the hirer. You are the hirer. Who are these guys?
Let me start with a tiny bit of background. When a human being, or sometimes a company or business, gets sued for personal injury in Minnesota, in Wisconsin, they have a right under the laws and statutes to have an independent medical examination of the person making the claim. They might call it an adverse examination, whatever. It doesn't matter what you term it. But
it's not the treating doctor.
It's not the treating doctor, and so the defense has a right to have the person examined. I think that's probably what they're talking about.
I think so.
And for example, today, I spent the whole day in the Twin Cities. You saw me screech into the parking lot just before we started.
I did. You seemed to be going the speed limit, though, so that was pretty good.
I was down there for depositions of 2 doctors that I had retained for a particular case. One of them is a physical medicine and rehab doctor who was head of the department for a major rehab down there.
Is that Dr. Helms?
It was.
Yeah.
And then another one.
You hired him again?
Another one was a vascular surgeon. Another one was a vascular surgeon that I've never met, had never heard of. We rarely have vascular cases.
Right.
This was an aortic ripping or dissection. And this doctor was, great credentials, Mayo trained. I found out just before we started that he is just operated on one of the Twins pitchers, and he works with all the pro sports. I mean, he's about as good as it gets. So if you want to call them hired guns, I suppose that's fine, but we exercise our right to have people examined by qualified physicians of various specialty.
All right, now, the man sitting next to you is chomping at the bit, so we got to let him go.
I'd say this. The more bizarre the case, the more likely you'll get an honest examiner from an insurance company, because they're just not part of the game. They're
Like an aortic surgeon.
Right. Where if it's an orthopedic injury, it's the same old. You know, the doctors that we see again and again in our office, we got, you know, stacks of reports. They all say the same thing. You know, it's just not a very frank appraisal. There's too much money involved. Last case I tried, the guy had made $9 million over the last 35 years doing adverse exams.
I would say this too.
Yeah.
Sometimes we do run in, on the plaintiff side, we see some of the same retained experts. We're kind of seeing more cases where plaintiffs are not using their treating physicians, they're using hired doctors, which is fine. But the other point that I think is important is that the jury hears about all of this. They know who's retained the doctor, they know what the doctor's compensation is. These days, whether it's his doctor, my doctor, somebody else's doctor, the jury hears all the background, and they weigh their opinions.
Another thing
accordingly.
that can take into consideration. Jim.
Sure.
One last comment that tacks on to Rob's comment, and that's this. More and more treating physicians are refusing to help their patient with a legal case by writing a report or giving testimony. And so I find that in cases I didn't formerly have to do so, I now have to find an independent medical examiner, and that exposes my client's perfectly good claim to the same kind of criticism we've just been leveling at Rob's cases. And it makes it more difficult for somebody with a perfectly legitimate case to prevail because his physicians refuse to help him.
That is a problem, and part of the problem is the splintering of specialties. So, you know, you have a client and they're hurt pretty badly, and all of a sudden you've got a physical medicine doctor, an orthopedic doctor, a neurosurgeon, a family doctor,
neuropsychologist.
A neuropsychologist. I mean, you got 5, 6, 7 people there, and some of them want to be involved, some don't want to be involved, and so sometimes you need to hire an outside expert just to kind of put it all together.
Sure. All right, back to border battle. Another caller. What are the differences in coverage between Minnesota and Wisconsin? And the caller goes on to say, if I live in Wisconsin but get in an accident in Minnesota, and the accident's not my fault, is the Minnesota coverage better? So, Jim, you can have that one.
Oh, gosh.
This is one of your treatises, Jim.
Yeah. In some instances, the Minnesota courts will impose the minimum coverages required by Minnesota statutes that are imposed on Minnesota drivers. However, frequently they will not. And there's a number of factors that depend on whether those minimum limits will be imposed. For example, if the Wisconsin driver who called in is in a crash in Minnesota and he's licensed by he's insured by a Minnesota licensed insurer, he'll probably qualify for no-fault benefits, and he'll probably qualify for underinsured motorist benefits.
Even if it's not in his Wisconsin policy?
Right.
Okay.
On the other hand, if he wants to force the other driver, who might not be a Minnesota driver, to have the minimum limits required by Minnesota law, I'm not sure that's going to be what a Minnesota court will require, and I'll defer to my two friends here.
Rob?
To me, the biggest difference just is that Minnesota has no fault coverage and Wisconsin does not. That could be a 5-minute topic in and of itself. But for handling cases, whether plaintiff side or defense side, that's the biggest difference.
Okay. We only got a couple of minutes left, so a couple of quick ones. Bob, I was just served with a summons and complaint. What should I do?
Well, get it to your insurance company right away, and probably that's it. They provide you with a lawyer. They've got insurance coverage. If your coverage is plenty for the case, and they'll kind of let you know, you're going to be okay. If it's a monster case and you've got limited coverage, then sometimes you want to get personal counsel to try and help the case get resolved. And we just had a case where I was personal counsel and he was liability
But the
counsel.
short version is call your insurance company
Yes.
immediately.
If you get sued, notify your insurer right away.
Yeah.
They will help.
All right, Rob, I was in a car crash about 4 years ago. Can I still sue? Can I still be sued?
Depends on whether you're Minnesota or Wisconsin, whether it's a Minnesota or Wisconsin statute. In Minnesota, you have 6 years to sue. In Wisconsin, you have 3.
Okay. Jim, I'll give you the last question. I'm in a car crash. I'm hurt. Should I just grab the phone book and just pick the first lawyer out of the book?
No. Minnesota motor vehicle collision law has grown so complex that the average or the general practice lawyer can no longer handle a case well. You need to pick somebody who has qualifications and credentials in motor vehicle collision injury law, and there's a lot of ways to do that. You can check what several legal directories, and you can ask around. Don't just pick them based on a TV ad, although we advertise.
All right, very good. You get the last word. So, unfortunately, that's all the time we have tonight. So for those of you who wanted to know about the rule against perpetuities from Mr. Barnes, that's our cliffhanger, because this is our last show of the season. I'd like to thank our panelists tonight, as those who have appeared on us all season long. I want to thank our viewers for tuning in and their interesting questions all season long. We'll see you back next year. I'm Sean Quinn. Good night.